Lords, good afternoon. Two introductory points, if I may. The first, just to orient my oral submissions. Can I take you, please, to the grounds of appeal, which are at page 13 of the full binder.
Yes.
My Lords will see there are three grounds. The first relates to risk of prosecution or sanction. The second relates to the relevance of the documents. And the third is the exercise of the discretion. The reason I take my Lords to this is, from my learned friend's submissions in relation to comity and abature, it might have become rather unclear where all of that goes. The answer is it goes in ground 3. It certainly doesn't go in grounds 1 and 2. They don't have anything to do with it. So I'm going to take it in the traditional way, as it were, work through these and deal with the abature point at the end. That's the first introductory point. The second introductory point is that this appeal has obviously changed complexion since it was made and permission was given by Lady Justice Aspling. The main event, which is the CSI document, I say the main event, was the main event below, before Mr. Justice Green, has, we say, in real terms, fallen away. So despite the strenuous argument before Mr. Justice Green, to the contrary, it is now clear that the defendant is at no risk of any adverse consequence from disclosing the CSI documents. And yet they maintain in this appeal that they do not want to give them to us. It is puzzling. We have not had any explanation for how this has come about or why it is happening. We have not been told anything beyond what is in my learned friend's skeleton, that something has happened between the application being made and the final skeleton being filed that means that they no longer rely on the real risk ground in relation to CSI. My Lords, those are the introductory points, and I'll take it as swiftly as I can. My Lords will have seen there are a lot of points raised. I will do my best to focus on the key ones, but I encourage my Lords, if I'm getting lost in the weeds, as it were, to move me along, because it may not be helpful to hear me on questions of detail. So ground 1, risk of prosecution or other sanction. This breaks down into 4 subgrounds. The first 3 allege errors of law, and the 4th is a sort of error of factual analysis. And just to be clear, none of this ground has any bearing on the CSI documents at all. That one is gone. It's only the SAR documents. So ground 1A is that the judge, when it came to the critical moment, forgot the real risk of prosecution test. We have 3 points in relation to that. The first point is that it is very clear from the judgment that the judge had the correct test well in mind. He gets it from the place that the test comes from, which is Bank Mellat. And if I can take you back to the judgment, we're in page 76 of core bundle, paragraph 23 of the judge's judgment. And as my Lords have seen, subparagraph 4, there it is, the critical articulation of the test, real in the sense of actual. Actual as opposed to not real. I mean, there are only so many ways one can say these words. It's very clear what they mean. And you'll see from paragraph 24, where the judge recites our submission, we emphasise that there must be a real risk of prosecution, that is, not a theoretical risk. The point about this, my Lords, is that it was common ground that the test was a real risk of prosecution. Nobody was suggesting there should have been a higher test. Nobody was arguing that it should be more likely than not, or likely or more probable than not. The judge then went on to look at a number of post-Bank Mellat authorities, and indeed pre-Bank Mellat, which articulate that test in more or less exactly the same way. My learned friend took you to paragraph 2.1 that we refer to, but there are many more instances in this judgment of the correct test being referred to. When you go beyond Bank Mellat, the same point is cited from Mr. Justice Butcher's judgment in the Tugashev case in paragraph 25. And this is from Matthews and Malek. not just a text or an empty vessel, but is regularly enforced so that the threat to the party is real. It's very clear what that means.
And you say that, but if one took paragraph 75 as the judge's explanation of what he understood real to mean, the use of the word real there wouldn't help much.
Well, he cited that after he cited Bank Mellat, which explicitly defines real as actual. So he does understand that it means actual. And I'll show you, because in his own words, he then uses that expression. So this is Tugashev. You get the same thing in paragraph 26, where my learned friend took you to. This is reference to Mrs. Justice Cockrell's decision in Joshua and Renner. And in the middle of that quotation, again in bold in paragraph 78, the rule of proof is a real risk of prosecution. So the word is being echoed through these cases, echoed by Mr. Justice Butcher, and it comes from Bank Mellat. It's picked up again in the NMC case, Mrs. Justice Mulder, that the judge refers to in paragraph 28. The quotation from paragraph 28, UAE authorities may well take breaches of court orders seriously, but that's not the test on the English authorities which this court applies. This court is concerned with the real, in the sense of actual, risk of prosecution in the foreign state. So that directly references Bank Mellat. And when he sums up where these authorities leave them, it's paragraph 30. That's his, as it were, distillation of the principles. On the assumption that an actual real risk of prosecution is shown, if the court orders disclosure, the court then has to conduct a balancing exercise. So that is the threshold. The same language appears in his citation of the Byers and Samba case, paragraph 33, Mr. Justice Fancourt. The balancing exercise should take into account not only the real risk of prosecution, so not just the risk, but the real risk of prosecution, and the decision of Mr. Justice Henshaw in Palladian Partners case, paragraph 36. This is in the context of not criminal prosecution, but potentially something else. In the final sentence of that, confidentiality obligations will often carry little weight without some evidence before the court that there is a real risk of an adverse sanction. And we know that he hasn't lost sight of that, because when he then goes on to actually apply the test to the evidence, that is the threshold that he uses. So if you turn on to page 103, his conclusion at paragraph 85, it seems to me the defendant has got nowhere near demonstrating that there is any real risk of a criminal prosecution.
I think the argument against you is that even if the judge, in the early part of the judgment, might have stated the test correctly, when he starts his factual analysis at 75, he explains it in the wrong way, and that would infect perhaps his use of the expression real risk in paragraph 85.
Yes, and I'll come to that language in a moment. But what I wanted to do at the moment was just bookend the language to show that when
the mere risk he that refers to real risk in 85 doesn't perhaps take us very much further.
Yes, well, I should say that's not. I mean, that's not the only reference. There are lots of other references to it as well, as I'm sure my lords will see when they have a look at the judgment. But paragraph 90.
A stronger position if he'd have said actual risk or something like that, perhaps.
Yes, I mean the focus on that argument today is an interesting one. Perhaps my learned junior can have a look for the word actual in the judgment, because I'd been looking for the word real, and now it said, well, that doesn't necessarily mean what it says. probably not helpful for me to do that at this stage. But
I mean, your paragraph, your point of paragraph 30
yeah.
makes the point that there the judge is using the expression real risk obviously to mean actual.
Yes. Yeah.
And
well that my lord, I mean, this brings me on to the second point, which is that the concept of real risk it's a familiar idea. The real prospects of success as opposed to fanciful prospects of success in summary judgment. The judges do know about this, and this judge, of course, dealt with a summary judgment application and strikeout application that came before my Lord Justice Newey in this case. This is not a very complicated idea or a complicated test. I mean, there is obviously a big difference between a test which is a real risk and a test which is it more likely than not. There is nowhere that the judge could have got that kind of test from. It's not a difficult concept, as it were. And the third point, I think, which I hope goes to explain what has happened here, this point is uncannily similar to the criticism that was made of Mrs. Justice Cockrell in Bank Mellat itself. If you turn to page 11 of the authorities bundle, sorry, that's not the reference.
It could be 111, I don't know.
It's paragraph 69 at 111. Yes, my lord has it. So what was said there was that Mrs. Justice Cockrell had, in giving an oral judgment the day after the hearing, had used the word a real risk of sanction, and so she was looking at the wrong thing in respect of this test. Can I ask my lords to just read paragraph 69?
Yes.
So it's a reminder that one needs to read an oral judgment fairly. And there is actually a real point of procedural importance here, which is that when giving an oral judgment, as the judge did, which is encouraged by this court, so as to give a decision quickly, and the hearing took place on the last 2 days of term, and the judge had helped the parties by giving that judgment on the 4th of August. When giving an oral judgment, judges may misspeak. They may not express every word perfectly. They are human, after all, not yet AI or robots.
The judgment was given orally. Was it truly extempore, or was it the judge reading out something he had written?
It wasn't read out. He had notes.
Yes, I see.
It wasn't read out. And it took 2 hours to deliver this. It's quite a long extempore oral judgment. It took him 2 hours. So by paragraph 75, where the words that have become muddled appear, he's been speaking for an hour without stopping, roughly. It's halfway through the judgment. What has happened here is very clear. It's very clear when you look at the judgment as a whole. The appellant here has identified one instance out of dozens of clearly, we say, correct reference. Excuse me, let me start. Makes my point that misspeaking is quite easy. The appellant has identified one instance out of dozens of references to the correct test in which the judge has just misspoken. He's reorienting himself. He's done with the legal bit. He's dealt with something else in between. He's coming back to it, and we can't explain it. It hasn't come out right. Clearly, it hasn't come out right. And the point when the appellant applied for permission to the judge, this point wasn't raised to him that he'd got the test wrong, where he'd said it was balance of probabilities. You can see that from his reasons. It's just not there. It's a different argument that's made about him getting all the facts wrong and the Abacha stuff. If it had been, he might have said, well, that's obviously not what I meant. I didn't mean that. And he then, was asked to approve this transcript very quickly because the appellant wanted to go off and apply for permission to this court, which he did, in August. So we say this is a really unfair point. When you step back and look at the decision in the round, the large number of authorities that the judge had before him, more than my lords have, all applying this test. It's very clear we have the right test in mind. So my lord, that's ground 1A. Ground 1B, it's the same. It seems to be the same story here. It was common ground before the judge that so ground 1B is the point that he elevated the requirement for prior prosecutions or prior actions into some kind of threshold point. It was common ground that they were relevant. Obviously, the appellant had dealt with prior instances or the absence of prior instances in their evidence. Our submission was that the absence of prior prosecutions in comparable circumstances was a highly influential factor in earlier cases. That's just what all the cases say that are cited by the judge. And therefore, it was a highly relevant consideration when deciding if there was a real risk. And that's the submission that the judge accepted. At no point did we suggest that there was a threshold requirement of a prior prosecution. The submission makes no sense. It's obviously just an evidential factor that goes to real risk. And that's clear from the authorities. And there is, with respect, no realistic basis to think that the judge simply rewrote the test of his own volition when nobody was suggesting this and put in a new threshold requirement. And the hook, the nail on which this entire bit of the appeal is hung, is again an isolated infelicity in expression in this oral judgment. So we can see what the judge did in relation to this point from paragraph 25 of his judgment, which starts at page 77, the core bundle.
So you say, sorry, I'm just going back to the first point. You say it was actually common ground, essentially. And I'm just looking at paragraph 18, where the judge essentially says that. So he wasn't being asked to say, oh, there is in fact some higher test.
No.
The parties basically agreed what the test was, although he says there were some differences of emphasis. Yeah.
Okay, one of the striking things about all of the authorities that follow Beck Millat is the court starts off saying the principles are common ground. There's Beck Millat. There's of course, it's very clear. It's very clear. So his lordship cites the Tugashev case, and he deals with the reference to the importance of prior prosecutions then. And then he goes into dealing with Renault. Perhaps it's bottom of paragraph 77, page 77, top of page 78. And my learned friend took you to this. The important thing about this is it makes clear that the whole issue of prior instances, prior prosecutions, is an evidential question. Clearly, if there is an explanation for why there are no prior prosecutions, then that is a relevant factor. And that was the argument in Renault. The applicant was saying, well, the law has changed and now things are much worse than they used to be because there's a new referral system for the French blocking statute. So that's the specific issue that Mr. Justice Cockrell was dealing with. But the fact that the judge engages with it shows that he recognises that it's just an evidential question. It's not a threshold test. And he describes the way this point comes into the Piffs case in paragraph 27 in a way that is consistent with that. He actually cites this in a slightly different context, which is what to do with competing expert views, principally in connection, I think, with the Singaporean documents, which don't concern my lords. But at the end of that paragraph, in 157, Justice Henshaw went on to say that there was no evidence in his case of prosecutions in similar situations, and that proved to be influential. Indeed, influential, not decisive. Nobody's suggesting that it's decisive or a threshold point. And even the sentence on which the defendant hangs its appeal, where his lordship says there needs to be evidence of prior prosecutions, as my learned friend accepts, he then goes on immediately thereafter, judge goes on immediately thereafter to say that they're important, not that they're decisive. I hope my lords have that reference from before that I can...
This is paragraph 28, is it?
Yes.
The top of page 80.
Yes.
So the agreement with you is highly pertinent.
Highly pertinent. So, you know, that all being the case, the setting it up, the way he expresses it in the rest of that paragraph, it is clear with respect that when he says there needs to be actual evidence, he's just expressing himself a bit informally there. It's not a new threshold test that he has created. And again, this point wasn't taken when the bank applied for permission before the judge. Otherwise, he could have clarified it and said, well, no, I obviously don't mean that. I mean, it's a relevant factor.
So when did they apply for permission?
After the hearing.
Immediately after the hearing. So before there was a transcript available.
Yes, exactly. Yeah. And it's obviously clear from the rest of the judgment, and we'll have to come back to this. And my other friend says, well, he doesn't then go on to look at the question of why there is no evidence of prior prosecutions. And we say that is absolutely not right. He does do that. There was a lively debate about that. I mean, to summarise the point, Mr. Bortan, the bank's expert, was saying there's no prior prosecutions because nobody would be so stupid as to do it. Well, okay. We said, well, that's not very persuasive. There's no anecdotal evidence. There's nothing else. And our expert, meanwhile, was saying, well, the reason there's no prosecutions is because this is not a priority for US prosecutors and the regulators when you look at their supervisory enforcement factors. So in summary, the judge finds for the claimant and prefers the claimant's evidence. So he does deal with it, which shows that he understood the text. But that is a question for the factual part of this. In terms of the law, which is what ground 1B is about, it's plain he didn't invent and then apply a threshold requirement of prior prosecutions. So that takes me to ground 1C, which is the regulatory sanctions point. So can a regulatory sanction be relevant? I mean, this ground of appeal is with respect, it's just effective. I mean, in respect to the first two, if my learned friend is right about what the judge meant, and if he meant what he said, then there is at least arguably an error of law here. But here there isn't an error of law even identified. They say the judge should have taken it into account, the risk of regulatory sanction. Well, he did. And again, nobody was suggesting before the judge that it was irrelevant. Our submission was that there was ultimately a discretion, theoretically it could be relevant, though it was bound to weigh less heavily than a criminal prosecution. And that is what the judge found. And I think my learned friend took you to the relevant passages. It's paragraphs 35 and 36. So he's been addressed on this point. It's obviously an important point in the context of this case, where regulatory action is potentially on the table. Deals with it at 35, and he ultimately agrees that it could only be contemplated in an exceptional case. So he obviously hasn't discounted it. And stepping back on this point for a moment, in any given case, all kinds of bad things could happen to a litigant from giving disclosure in this jurisdiction. Could be criminal proceedings, there could be civil proceedings, could be a risk of embarrassment, loss of customer confidence, falling out with your business partners in another jurisdiction. Other things being equal, those things are going to weigh less heavily than a risk of criminal prosecution. It's just common sense. And we adopt, with respect, the points articulated in argument between my learned friend and Lord Justice Snowden. all other things being equal, the criminal sanction is going to weigh the most heavily in the balance. It's just common sense. And with respect, if that is the point that's being attacked, then we say, well, they're wrong about that, and the judge was right. So that in this context, the judge was criticised for saying that if the defendant doesn't get there for a criminal risk, then it's less likely to get there for a risk of civil enforcement. And it said, well, that's illogical because you need to deal with the two separately and independently. But of course, when he's talking about this, he obviously has in mind the actual evidence, which he's now read, digested, and made a decision about. And the evidence in relation to what might actually happen by way of civil enforcement is basically non-existent. So he didn't have very much to go on. And one can see, as a matter of principle, one can see that if there were a case in which it was very clear, for example, that a bank would lose its banking license because the regulator had already said that it was going to lose its banking license, one can clearly see that that's possible. It can weigh in the discretion. That's what a Batcher tells us. It can weigh in the discretion. But this case is all about what the sanction is for this defendant, and there's nothing like that in the evidence. So beyond that, the ground is about what the judge thought about the defendant's evidence. It's not about the law at all. There's no error of law that's been identified. Ground 1D then, this does attack the judge's conclusions on the evidence. There are two overarching points here before I get into a little more detail. The first is that this really is just an attempt to re-argue the application on this point, and it should not be permitted. The assessing and weighing of evidence in respect of a disclosure issue is squarely a question for a first instance judge, and this court should be slow to interfere. The judge had 2 full days of argument. He had a number of pieces of evidence which are not before this court, nor should they be. So unless something has plainly gone wrong, there is a clear error, which we say there is not.
Let me divert you one moment, but sort of following on from that. If we were persuaded that the judge's decision could be impugned, the question would arise, should we try to work out the answer ourselves or should we remit it? Mr. Allen said we should try to work out the answer ourselves. Would that be your position or do you take a different position?
I think my lords would be in a quite difficult position with that kind of exercise. It's not, if you were to conclude, let's be very clear about this. Our position is, even if there was a real risk in these cases, clearly disclosure should be, in this case, clearly yes, disclosure should be given. But if my lords were to get into the territory where you were trying to decide where it sits between a real risk and a certainty, that's not easy for my lords to do, particularly on the excerpts of evidence that are available. So it may be that it would have to be remitted. That's my, without a great deal of consideration, that would be my answer. And my first answer is that if my
we don't get there anyway.
We don't get there, and if you were to conclude that there was a real risk, but as in some of the other cases, Chugachev, for example, it's not a very substantial risk, it's not a very high risk, you could still nevertheless, get there based on that analysis.
Yeah.
The second point about this, the overarching point, is the nature of the exercise that the judge is conducting when deciding about a real risk of prosecution. It's not a finding of historical fact that he's making. It is a prediction about what will happen if disclosure is ordered. So the issue is inherently an uncertain issue, and there is inherently unlikely to be a right answer to it. And we say that underscores the wide latitude which the judge should be given. There is a further sub-point to that, which I'll make briefly, but a number of these cases, they arise in a commercial context. Of course, that makes sense given the issues that are in play. And judges do bring to the analysis their own experience of how commercial parties behave, how foreign states behave, how regulators behave. There is an element of stepping back when you've looked at the evidence, as the judges do in these cases, and asking themselves, based on what I know as a judge, is this realistic, that these bad things are going to happen? And that's a feature of these cases, and we say it's right that it should be a feature of these cases. The judge should bring that experience to bear. But that's the experience, as it were, of the first instance judge, and this court should be slow to substitute its view of those matters for the first instance judge. So, with those introductory points on this ground 1D, and question of risk of prosecution, the first place to go, I suppose, is Mr. Dass's evidence, the K2 evidence, and I can deal with this fairly shortly.
Just while I've got you, I think your point about the judges, the length of the judgment and the oral reasons and everything else, reminded me of it's Piglaska and Piglaski. I'm sure your junior can provide you with a copy of the relevant paragraph, but I think you say that this court shouldn't get into a fine linguistic analysis or a narrow textual analysis, I think Lord Hoffman said, of a judgment which was given, reserved, but based on notes.
We absolutely say that. It's not a written judgment, it's not the US Constitution, you can't read it like that. There will be, it's reasonable to think there will be infelicities in a judgment that's given orally.
There seems to be quite a lot of room for doubt about the meaning of the US Constitution.
I'm not sure that's your best analogy there.
Well, we adopt the point.
Well, it's just, okay, I mean, just for everybody's note, in case everybody is interested, it's 1999 1 Weeklies 31360 at 1372. So I just read that into the transcript.
Mr. Dass's evidence I can deal with shortly. Mr. Dass literally had one job, which was to explain that a breach, that it would be a breach of the BSA, the Banking Secrecy Act, to disclose SAR and SAR documents, and that if it were to happen, to opine on the prospects of a prosecution by FinCEN in the circumstances of this case. Is it a possible thing that might happen? Is it likely? Is it inevitable? Is it probable? We're in the realms of probabilities with this issue. So what is the probability? And he just doesn't address it. He has not asked the question, and he doesn't answer the question. And that's the judge's point that my learned friend took you to in the judgment. And in our submission, that is an unassailable conclusion on this evidence. And with respect, it's a bit rich for the appellant to say now that it may not be a proper question for expert evidence at all. And Mr. Bortan, on the subject of the CSI, he's very happy to roll up his sleeves and get stuck in. I mean, I can show you that. Some supplemental bundle, page 183. This is his reply, so the last thing that comes in from Mr. Bortan.
Sorry, well, I think I've got the wrong page. Which
It's
page?
a supplemental bundle, page 183.
Oh, I have got the right page.
Yeah.
Yep.
You'll see that the first new paragraph starting in the context of disclosure in a civil litigation such as this, a regulator would likely feel compelled to pursue a civil enforcement action. So he's given an opinion. So you can't now say, well, it wasn't appropriate for Mr. Dass to do that. I mean, it was clearly thought to be appropriate for Mr. Bortan to do it. And indeed, my lords don't have it, but the pro legis evidence which concerned the Singaporean risk of prosecution also dealt with the probability question. And we made the point to the learned judge that it is hard to conceive of a more experienced banking litigation team than we face in this case. They plainly knew the target which this evidence needed to be aimed at. And this letter, K2 letter, would have gone through back and forth. Can you clarify this? Can you expand on that? And of course, Mr. Dass is perhaps uniquely well experienced and qualified to opine on this question, because he was actually, and until recently, in charge of the prosecuting authority as acting director until September 23. Now, importantly, and contrary to submissions that were made this morning, this point has nothing to do with whether there was evidence of prior instances of enforcement. Mr. Dass could have said, if it were me still in charge, I think this is how they would have dealt with it. They would have looked at these enforcement factors and we would have likely brought a prosecution. or we wouldn't have bothered because the bank is in England and that seems like quite a lot of hard work over these few documents. Somebody must have asked him the question when this letter was being prepared. And bluntly, it can properly be inferred that he was not willing to give a more helpful answer. And that submission sits behind the judge's remark in paragraph 101 of the judgment, where the judge says, he does not even seem to have been asked the question despite that being the core issue on the application. And in fact, there's no mystery here, because when Mr. Das deals with the enforcement factors, he does it at the end of his report in the context of sanctions. It's at page 155 of the supplemental bundle. It starts at the bottom. I'm not going to read out the enforcement factors, but if my lords have a skim of them, I would suggest that you would come to the conclusion that there would be no prospect of a prosecution in this case.
Sorry, I've lost the page.
155.
55.
The enforcement factors include things like the pervasiveness of the wrongdoing, history of similar violations, financial gain or other benefit resulting. None of it bears any relationship to complying with an order of the form. And I just finally add the point on this. My friend said FinCEN had been asked and had refused. So they were asked 5 months ago, and so far as we're aware, there's nothing before the court from them responding to that request. It was in June that they were asked. So well, that is K2 and the SARS. Then you have the CSI issue, but only insofar as it's relevant to the SARS and the SARS-related documents. Now, my learned friend effectively didn't have time to deal with any of this, so it's a little tricky for me to know how to take it. But what I will do is explain in brief terms what the judge did. So when he gets to dealing with the risk of prosecution and the risk of civil enforcement, it's the risk of prosecution is dealt with in paragraphs 75 to 85 of the judgment. And then the risk of civil enforcement is dealt with in paragraphs 86 to 90 of this judgment. And there are a large number of significant points made by the judge in carrying out that analysis, in respect of which there is really no engagement at all on this appeal. Yet it said that he got this factual question wrong. So just to summarise briefly, as much for the benefit of the transcript and your lordship's note as anything else. In respect of the criminal prosecution risk, judge, so he starts with paragraph 76. He accepts our submission that Mr. Bortan, Sullivan and Cromwell lawyers' objectivity has been affected by his role in the underlying matter, so he doesn't want to place great weight on his evidence. He makes the point in paragraph 78 that what Mr. Bortan actually says about the risk of criminal prosecution is pretty flimsy. He just says, well, perhaps there would be a referral to a criminal enforcement authority. He makes the point in paragraph 79 that the prior cases that anyone has found for prosecution are very far removed, involving literal theft, conversion, using this kind of material for personal gain. He makes the point in paragraph 80 of the judgment that Mr. Bortan's reply didn't contradict Mrs. Ramon's evidence and analysis in relation to enforcement priorities. He makes the point in paragraph 82 that there is no real analysis in Mr. Bortan's evidence of the impact of the English court's order on the decision-making process. He makes the point in paragraph 82 that Mr. Bortan used the words conveying without authority, which are from the statute, but without providing any evidence about what they mean and how they could apply to the situation. No evidence of any prosecution based on those words. And finally, at paragraph 84, he relies on the FRB consultation paper, which states in terms, unauthorised disclosures which lack intent, such as those made inadvertently, would not be the subject of prosecution. where the requisite criminal intent to steal or knowingly convert the information may be present, criminal prosecution may be appropriate. So he does a whole analysis. He gives a whole stack of reasons for why there is no real risk of criminal prosecution here. And then he gives additional reasons in relation to real risk of regulatory action. And you see those in paragraphs 86 through 90. So in 88, he refers again to the only instance of a civil regulatory action against ICBC. And he says it's quite far removed from the situation here, which indeed it was. He deals in paragraph 87, and I alluded to this earlier, to Mr. Bortan's explanation for why there are no prior instances of a prosecution or action in a case like this. And Mr. Bortan's explanation was everyone complies, and the judge says there's no evidential basis for that. And there could be, we made the point, in theory possible to put forward evidence to support that. I mean, Mr. Bortan is a very experienced lawyer in a firm in New York. He could say, well, I've had clients who've had this before, and this is the decision that's been made, or I've phoned around my colleagues, but it's just, you know, he just says it. Well, I think everyone's going to comply. So the judge doesn't place much weight on that. And he goes on to look at, in paragraph 89, Miss Rimon's explanation for why there are not prosecutions. And she says she's looked at the published supervisory priorities of the FRB and NYDFS, and they're just not very interested in enforcement of regulatory record-keeping violations.
Sorry, where do I find that?
So that's paragraph 89 of the judgment. So he quotes Miss Rimon's report in 89.
Yes.
Quotes his conclusions about how it's all very discretionary, and she can't really, see how you'd be in trouble in this kind of case. It's all about egregious misappropriation of CSI for personal gains, she says in that quote. And the judge says at paragraph 90, this all makes a lot of sense to me. It has not really been countered by Mr. Bortan.
Is the judge right to say that the order would be extraordinary?
Where does he say that, my lord? Yeah.
Right at the bottom of the page, just where you've read from. It's an exception, but is it extraordinary? It's
probably not right to say that it's extraordinary, but what the judge meant, it's quite an odd word to use in that context. Now, I would suggest he probably means exceptional. This extraordinary just doesn't seem to fit. He is talking about something that's unusual, rather than something that's sort of remarkable or surprising. Now, that's what the judge has done, and we say that's decision of a first instance judge, having looked at all the evidence, there is really no grounds to say that he's got that manifestly wrong. Of course, standing here today, the position needs to be updated because his prediction was absolutely right in respect of the CSI documents. There is no prosecution or other action or sanction on the horizon. It's been accepted. His judgment is no longer challenged on this point in respect of the CSI documents. So when Mr. Bortan says in his letter that I took you to, that the regulators would think they had no choice but to bring enforcement action, Mr. Bortan was completely wrong about that. Now, when that's piled on top of the judge's own criticisms, this evidence really has no credibility. The judge was right. The evidence about the risk of regulatory action in respect of the bulk of the CSI documents basically now has to go in the bin. It's been proven to be incorrect. And we make the point in the skeleton. It's hard to see how defendant can be better off now than they were before Mr. Justice Green on this. As it happens, the judge was also completely right about the mass documents. We had the same fight in relation to the Singaporean prosecution, and we've been told Singaporeans are, not going to prosecute. I may have misspoken there, but there's no longer any issue in relation to that.
Just on that, the monetary authority of Singapore indicated that in light of the order, they would not object to disclosure. So it's not a case of unauthorised disclosure in Singapore, if I can put it like that. A consent or non-objection was forthcoming after the hearing.
I'm very grateful. Yes, so that's the thought that I had in my mind, but didn't articulate very well. So against that unpromising backdrop, there are 4, we say, somewhat sort of random factual points taken in my learned friend's skeleton in relation to the exercise of the factual decision on this point. And it's paragraph 29.5 of the skeleton. I'll just deal with these as briefly as I can. So these are the four factual points that are drawn out. So the first is that there's been a refusal to give permission by the FRB and NHS. Well, we say the judge obviously was entirely aware of that. He considered it. It's at page 90 of the judgment for what it's worth. He didn't think it made any difference. He made the point that refusal is a feature in almost all of these cases. The second point in 29.52 is that unauthorised disclosure of CSI may be treated as a criminal offence. Well, that doesn't help. That's common ground. It doesn't tell us anything about the risk of prosecution. The third point, which refers to the wording of the relevant statutory offence. So he should have focused more on how it referred to a conveyance and disposal and not just conversion and misappropriation. He did consider that, and he rejected it based on Mr. Bortan's evidence, which sought to put that language in play, but without providing any explanation for what any of it meant. So I've taken you to that. It's paragraphs 82 and 83 of the judgment. So it's not for the judge to read the US statute and think, well, this is what I think it means. Or it's being submitted to me that this could be covered without any assistance of the relevant US law. And the final point, 29.4, the FRB consultation paper. The short point here is the judge was obviously entitled to read that document and consider it. And I mean, in fact, he says he would have reached the same conclusion anyway because it's obvious from the wording of the statute. He deals with it at paragraph 84. I referred to that earlier. And the criticisms that are in 29.5 of the skeleton, subparagraph 4 in letters A through C, these are, with respect, they're either wrong or irrelevant. I mean, they just don't take things anyway. It's clear what the consultation paper is saying, and the judge was entitled to rely on it. So I'm not going to, as it will, work my way through those unless it will be of assistance. And of course, that accords with the evidence of prior prosecutions. The only prior prosecutions were in cases of egregious misappropriation of that. So all of that being the case in respect of the risk of prosecution, the defendant nevertheless insists that for the SAR documents, that's the wrong conclusion. Which raises the question, well, why? I mean, what's different about those? Yes, they're governed by the BSA, but the evidence of Mr. Das doesn't help us at all. FinCEN is the regulator in respect of the DSA. So falling back on the CSI evidence, that's the evidence of Mr. Bortan. Well, what is left to explain why there is a risk in relation to this limited category of documents when the risk has evaporated for all other types of CSI? And we say, well, there's nothing. So this attack on the factual conclusion is, we say, without merit. And even when one thinks about the purposes behind a SAR confidentiality for a moment, my learned friend went over that quite briefly. It's in Mr. Das's report. But these are very old documents going into a confidentiality ring. There's no scope for tipping off. There's no reason to think that disclosure within a confidentiality ring of a handful of SARS and SAR documents would inhibit compliance personnel from filing SARS in the future. I mean, there's no evidential basis at all for that kind of conclusion, and it is contrary to common sense. And despite what the regulators have now seemingly said to the defendant post applying for this appeal, they have not said, well, we're still going to come after you, or we're going to come after you if you disclose the SAR documents or the SARS. We will refer you to the DOJ if you disclose it. They haven't said that, because if they had said that, we'd have been told about it. So we say that with categories 1 to 6 of the CSI docs off the table for this purpose, it is wholly fanciful to think that there will be any risk of prosecution for what is left. So just pulling some threads together on that, in our submissions, clear on the authorities that if there's no real risk of adverse action, then there's nothing left to weigh in the balance. And you see that from Bank Mellat and the later cases. Comity might still affect the form of order, of course, and that justifies a confidentiality ring, which we have always been happy with in this case. But in those circumstances, disclosure will be given. There's no weighing that you get into at all. There's no fair trial considerations. There's no attempt to assess the probative value of documents that the court hasn't seen. That is ground one. Unless my lords have any questions about my submissions on that, I'll move on to ground two, which is the error in failing to find that the documents were not, as the defendant wanted the judge to find, of tangential relevance. Again, starting with an overarching point, which is the nature of this decision. Relevance was obviously a factual question for the judge, but it too involved a large element of prediction. What is the possible impact of documents on a fair trial once their content is known, once they have been analysed, once they've been assimilated into the factual matrix of this case? Might they be significant? And again, there is inherently no right answer to this kind of question. So a first instance judge should be afforded a wide ambit. In this particular case, as my learned friend accepted, Mr. Justice Green is the designated judge for this case. He has sat through 5 multi-day CMCs over the course of 2 years, including 2 heavy strikeout applications. My Lord Justice Newey will be familiar with in respect of the first of. And he will be the trial judge. He's docketed to be the trial judge. So he's uniquely well placed to answer the predictive question here. And this court should be very slow, we say, to substitute its view on the question of relevance. Overall, this ground 2 really amounts to a sort of scattergun attack on assorted factual points. And we say it just doesn't come close to showing that the judge made a plain error on the question of relevance. There's some criticisms of general approach, and there are criticisms on specific points. If I can start with the criticisms of general approach, the first criticism is that the judge simply relied on the fact that the defendant had classed the documents as relevant. We say that is wrong, and even a cursory reading of the judgment shows that he has engaged with all of the evidence that was before the court on this question, such as it was. So if you turn to page 92, you'll see at paragraphs 60 onwards, the judge engaging with the various categories. And just by way of example, categories 1 and 2 I dealt with in paragraph 61. And he refers to Mr. Lewis's explanations of what was in the documents. He refers to Mr. Lewis's evidence that they were of tangential relevance, and the judge ultimately says, well, he's not persuaded that they can be so easily dismissed as being tangential. So he hasn't just sat back and said, well, you've disclosed them. It was the fact that they were disclosed was one factor of many factors relied upon, including what was put in evidence. But we do say he was entitled to place significant...
I don't want to take up a lot of time on this, but I asked this question earlier on. Have these documents been disclosed or not?
No.
So you just said, I think in the something you just said, they've been disclosed, but they haven't yet been disclosed, as I understand it. They're asking for an order that they be relieved from the obligation to disclose. Is that?
Yeah, they haven't been disclosed. They have been categorised as relevant. That's perhaps,
internally.
well, I suppose so, and that's
They've come to the decision that they're relevant and they would disclose them if they're not relieved from doing so. But they haven't disclosed them in the sense of putting them in a list.
That is the position.
Right.
Yeah. And in respect of the SAR documents, they say they can't identify the documents. But they actually say they can't even identify the non-existence of the documents or the existence of the documents, which left us querying how we were able to have this debate about them. But there we are. That was a point that wasn't explained below. I mean, we said it went to the risk of prosecution. But yeah, my lord is right. I'm talking about the classification, categorization as relevant. But we say the judge was entitled to place some weight on that in the context of this case, because the defendant, our submission hasn't exactly taken an expansive approach to relevance in this case. I mean, they said they've reviewed 1 million documents. They're disclosing 50,000. It's 1 in 20 documents that's been categorised as relevant. And there was correspondence before the judge showing that various documents had been reclassified as irrelevant in the run-up to the hearing. So the numbers were coming down. The disputed documents were coming down. They had been re-reviewing the documents. But despite giving these documents anxious scrutiny, they concluded that they do have a probative impact on the issues in the case. It's not just that they mention things, it's that they're actually relevant. And so that sort of potted history is what the judge refers to in paragraph 66 of his judgment. So it's the final sentence of paragraph 66. It's not just the fact that they have been on the first pass to put in the relevance box. He says the important point is that after a number of relevance reviews, including recently during the course of this application, there's still a significant number of documents that have been deemed relevant to the case by the defendant's lawyers. And that's the context for that comment.
Is this a case where I'm assuming it is one where there have been issues for disclosure and so on? And that's all been decided, right? So the judge has been through the exercise of saying, or perhaps it was agreed, here are the issues for disclosure.
Yes, exactly. There is a DRD containing issues.
So disclosure is being given by reference to those issues.
Yes, the searches would be conducted by reference to those
issues. Yeah.
So the first general criticism is that he, as it were, stops at them being classified as relevant. And we say, well, it's obviously not right. He refers to other things. He refers to what's said about what's in the documents. The second criticism is that he did not undertake the required analysis, and what he did was superficial and inadequate. That's from what my learned friend says in his argument about what the judge did on this question. We say that's unfair. The judge dealt with this in an oral judgment. Judges giving an oral judgment can't be expected to address each and every single granular point that's taken. I mean, they need to give sufficient reasons. But otherwise, giving the judgment would take as long as the argument. Nevertheless, there are 10 pages of analysis in this judgment, running from paragraphs 44 to 66, in which he goes through each of the categories of the CSI documents. It's clearly identified what they are being said to comprise. He goes through some of the relevant issues in the case, which we put before him, arising from the settlement agreements. He goes through what Mr. Lewis says about the relevance of the documents or the content of the documents in the categories. And ultimately, he concludes that he can't accept, on the basis of the evidence available, that the documents are just tangential. So again, I'm not, in the interest of time, I'm not going to read out all of those paragraphs. My lords will see them and see what the judge has done. We think that what the defendant is really saying here is that the judge should have accepted their analysis, Mr. Lewis's evidence, as dispositive. If they say that these documents are tangential, then they're tangential. And he says, no, they say, well, we didn't really engage with that. I mean, we obviously say it's wrong. We say that they've got it wrong, and we think we can make something of these documents based on what's been said. But obviously, there's only so much that anyone can say about this on the basis of what's been put in Mr. Lewis's evidence. The point is that the judge wasn't bound to accept the defendant's evidence about this. He was not bound to accept that the documents were tangentially relevant or of limited use, or merely had a nexus, one of the pieces of language used in the evidence, with the issues in the case and so on. And in this context, my learned friend refers to the party's decision about the relevance of a document. He says, well, parties can be trusted to do the relevance review. So what's so different about this? Well, that doesn't help. I mean, yes, the initial responsibility is on a party to do the relevance review, but the court is not bound to accept their decision about it. Right? If it's challenged, if there's a serious challenge to that, then of course the court can make a decision. The court can say, well, we got this wrong. Now, it's hard to see how it would ever arise in practice in a situation where one party has the documents in their hand and is saying, well, these are not relevant, because the judge would say, well, let's just have a look at them. But the point is, it's a very different situation where there is an active challenge to what's being said, and the judge is being asked to just accept at face value what's being said. We say the judge, I mean, one of the interesting things below, as the judge remarks on in his judgment, is that there's not very much learning on how to approach this question of relevance where there is a serious dispute about what documents might show. And we showed the judge Mr. Justice Bright's decision in Eurocase.
And just to be clear, the question of relevance or the question of significance?
Significance, yes. So what is it you need to show? You need to weigh significance against risk. That's the balancing exercise. But how do you go about dealing with significance in this rather difficult procedural situation where one party has the documents and the others don't? And Justice Bright's approach in Eurochem, which is cited by Mr. Justice Green, was that he asked himself whether he could discount the possibility that these documents could be significant. And we suggested to the judge that that was a helpful way of looking at it. And there isn't really any engagement by the appellant with that point, and there isn't really any criticism of the judge for adopting that approach as such. And we say that that approach is necessitated by the rather unusual situation where one party has been shown, or one party has the documents, court doesn't have the documents, we don't have the documents. It's not a level playing field. I mean, one party holds all the cards and they have an agenda. They're not neutral in all of this. They want to succeed on their appeal, on their application, and now they want to succeed on the appeal. So, we say, well, why should Mr. Lewis's opinions be dispositive of these questions? We might well disagree about whether something is tangential. When we look at the document, we put it in the context of the case. So, my lord, we say that there's no general error in approach here. And it's quite wrong to say that the judge's approach was superficial, that he didn't get into that. So, moving from those general criticisms to the more granular ones. These appear in paragraph 47 of my learned friend's skeleton argument. And again, they're slightly random factual points, and I'll try and sort of whack them a bit like a sort of whack-a-mole as I go through them. But the overarching point, of course, is that this is a decision on the fact that this court ought not to substitute its opinion on. So if my lords have paragraph 47, the first point is that this was proceedings are concerned with misconduct that occurred in New York, and this misconduct which led to the settlement agreements were in the UA branch and the UK wholesale branch. The fact that the case primarily, doesn't exclusively, but primarily concerns misconduct in the UAE in London doesn't mean that communications between Standard Chartered New York and its US regulators are not going to be material in this case. I mean, after all, the sanctions breaching payments went through Standard Chartered New York, and as a consequence, those were the regulators that investigated saw through and were party to the 2019 settlements. So the documents leading to those settlements, we say, are obviously absolutely fundamental to this case. And that's the category 4 documents. And I don't think that's even seriously disputed. Those are the communications. And we know, insofar as we've got the category 1 to 3 documents, that those are not limited to Standard Chartered New York issues. I mean, that's why they've been categorized as relevant. We know, because Mr. Lewis tells us in his evidence, that they address group-level oversight and compliance issues, as well as issues in the UAE branch. And the judge, at any rate, he knew what the case was about. He was alive to the New York point. He mentions it, or deals with it, in paragraph 57 of his judgment, page 91. And he says, in the middle of that paragraph that's at the top of the page, settlements were with FRB and NYDFS. They were the parties that investigated the misconduct, even though the alleged misconduct took place in UAE and London, and those investigations took place over 5 years or more. So he's alive to the point that this is a New York pocket of regulatory documents. He nevertheless considers that they could be relevant. So that's the first point. 47.2, we're told most of the categories affected have nothing to do with the investigations which led to the 2019 settlements. Now, that's a reference to categories 1 to 3. So the monitor reports, category 3, let me take them in order. Category 1, the examination reports. Category 2, responses. Category 3, the monitoring reports. We say that is just a non-point. I mean, whether or not these documents formed part of the investigations, they may still be relevant and talk about the underlying conduct which form part of these settlements. And they must do, because we're told that they talk about the group compliance issues. They may tell us about whether regulators were misled in 2012, because of course that's part of our case. What the monitor had discovered in its monitoring role. So the monitor was appointed pursuant to the 2012 settlements. There's no reason to think that it only looked at the exact same issues that arose in 2012. It would have been concerned with the wider compliance position. So, well, we say at this point that these documents are not part of the discussions leading to the settlement is a non-point. It doesn't show that the documents couldn't be significant. The point that's made in paragraph 47.3 seems to be the same point, so I'm not going to address it separately. They say the judge didn't get this point, but we say, well, I mean, he clearly was alive to what these categories were, and he looked at what Mr. Lewis had said about what was in them, and he reached the conclusion that he reached. He was entitled to do so. Paragraph 47.4, these are the category 4 documents. Those do concern the investigations leading to the 2019 settlements. They are plainly and highly relevant, and it's not really, in my submission, disputed that they contain things of significance in respect of, amongst other things, PDMR knowledge. Instead, the arguments that are resurrected in paragraph 47.4 really amount to saying that we will see other material anyway, internal discussions and so on, so we should just be happy with those. The judge dealt with that submission below and he rejected it. It's paragraph 66. We say he was entitled to do that. So he accepts the point, paragraph 66, that the categories 5 and 6 documents will be provided, and that the defendant says they'll be of much more probative value as they will deal more directly with PDMR knowledge. The judge says with the limited information he has, he doesn't think he can safely assume that. So overall we say, my lords, that the judge was squarely within the ambit of his evaluative judgment on this point. That, I think, leaves the SARS, the relevance of the SARS. They are dealt with, paragraph 47.5 of my learned friend's skeleton. We say it is plain that these are highly relevant. Mr. Lewis's evidence about that is at page 130 of the supplemental bundle, in paragraphs 47 to 49.
Should we turn that up?
Yes.
130.
130. Starts under the heading USR documents just before paragraph 46. It may be best just to allow my lords a few moments to read those paragraphs.
So which paragraph?
It's 46 to 49. So
Yeah,
just over the
I'll
page.
do that.
So, my lords, we're told that they concern potential Iranian sanctions breaches, e.g. shell companies being used to avoid US sanctions, online banking transactions being made from Iranian IP addresses. So those are two examples of the misconduct that that bank was fined for in 2019. They are literally the 2019 settlement misconduct. So these SARs deal with that. It's a SAR, a suspicious activity report. As my Lord Lord Justice Snowden suggested, that the suggestion is that they would contain some synthesis of the misconduct. And the point that regulatory document or a report or something that brings the material together can be highly probative. I mean, we rely on that point. It's a point that is made by Mr. Justice Bryan in the Glencore case, which came after our decision. Again, was a case in which disclosure was ordered, and in that case, in respect of 4 documents. So we say the numbers point is not a very good one. And one of those documents was a prosecutorial brief, something of that nature. So we say the SARs are the very synthesis of this misconduct. And just taking them by themselves, they will show us what the bank actually knew about that misconduct, and it will pin it at a point in time. We'll see when the SAR was produced. We don't know at the moment. And we'll know that that's the latest time at which that information was known. And there may be more information about it. It may speak to the circumstances of the discovery, who was involved in that, what steps were taken to investigate it, when, and by whom. It is a report, it seems. And then there will be potentially communications of those documents and about those documents, which are directly relevant to the question of PDMR knowledge. And we're told by Mr. Lewis in the evidence that we have just seen that they were circulated in 2015 in the context of Project Larch. And as the judge notes, the Project Larch recipients include PDMRs. So 2015 is 4 years before investors were told that any of this was going on. That's what we say. That's our case. So we say
so
that
really simplifying things massively. Part of your case is that the defendant knew about all this extra stuff that was not disclosed in the 2012 settlement.
Yes.
And didn't tell the market. And only told it in
yes.
2019.
Yeah,
is that-
shortly before.
I'm
they were
really
fined.
massively simplifying, I accept that. But
No.
that's, and so you say that this might be relevant if it shows that a PDMR knew about further conduct which had not been previously disclosed. Is that it in a nutshell?
Yes, so there are obviously different limbs to the case. For just focusing on the moment for the misconduct that was described in the rather anonymised form of the 2019 settlement agreement. The judge refers to that. So it's quite hard to tell the detail of the conduct from a settlement agreement and a statement of fact. But those pieces of misconduct, we say, should have been disclosed much earlier and were known about much earlier by PDM. So in a nutshell, that is right, and after 2012. So there will have been, it seems, we now know that there were suspicious activity reports earlier than 2015 concerning the conduct which the market was told about in 2019. So it's relevant to see who that went to, whether it went to PDMRs, and what it said. Because of course, if it was all rather benign, then that would support potentially the defendant's case that there was nothing material. If it all looked terribly serious, in the context, let's not forget, of a regulatory settlement and a very large fine in 2012 and a monitor sniffing around in the background, if it all looked very serious and like it was going to lead one way or another to a fine, then that's highly significant for our case. Does that answer my Lord's question? Maybe it answers an attempt to make the case simple by making it...
I'm just trying to understand in a very simplified and I accept, as I put it, massively oversimplified probably sense, a strand of your case.
Yes, exactly.
Yeah.
Yep.
What does the last sentence of paragraph 47 mean?
Of 47 of...
Sorry, the extract you asked us to read.
So this is Mr. Lewis's evidence. Well, we have really puzzled over that sentence on our side. It seemed to us an attempt to downplay the probative value of these documents by erecting a sort of non sequitur. We say they're going to be relevant to what the misconduct was and what PDMRs knew about it. So to say that they don't evidence the awareness of a PDMR of alleged representations in statements made to the market, it's a sort of Aunt Sally point. Well, what's that got to do with anything? It's not our case that this document would do. Other documents might do that. Documents showing their involvement with the representations combined with documents showing what they knew about the true position. The case would be built from inference in that way, but put like this, it just doesn't take things anywhere. So that's why we describe it as a conspicuously narrow approach to the question of relevance.
Is he making a timing point in paragraph 47? This is the SARS are pre-November 2015.
There is no relevant timing point so far as the case is concerned. Our case is that the investors were not told about the matters until 2019. So whether it's 2015, 2014, 2016 makes no difference. That timing point is neither here nor there from the perspective of our case. So we've really puzzled over paragraph 47. But that's what he says. And what he says gives us, and gave the judge, we say, enough to go on.
I certainly take the first part. Limited probative value is not no probative value. Yeah.
Yes, and raises the question of what he means by that. They being the defendant who defend the case, saying they didn't, they're not liable, they no doubt would see it as insignificant. We may see it as very significant. It's part of the problem.
Well, I suppose it could be of probative value, as you say, in not supporting your case. But anyway.
Who knows? The response that is given is akin to saying, well, it's not relevant to reliance, and so you shouldn't have it. Yes, we're not suggesting it's relevant to reliance. It fits in a different place into the evidential matrix of the case. So we say that this material is all at the heart of the case, and that's what the judge finds. It's paragraphs 97 to 98 of his oral judgment. He deals with it quite briefly because he spent a long time dealing with the CSI documents, which have been the main event before him. Fair enough to do that. These documents were dealt with equally economically in all submissions before him as well, because we used up a lot of the time on the other stuff. My Lord, that's what we say about the relevance of the SAR documents. I'm very reluctant to spend any time. I think I'm doing all right. Going to say going through the sub points in 47.5a about why the defendant says the judge got the analysis of the relevance of the SARS and SAR documents wrong. If I can take it quite briefly. The first point, so there's points A through E that are there. First point is there's no dispute that the sanctions breaches found in the 2019 settlements took place. Well, that is true, but of course, as the judge says, the settlement agreements are in very anonymised form. They're very vague, and so part of these documents will go to explaining what the actual granular reality of the conduct was. Point B, the making of a SAR is not itself probative of any misconduct by a customer. And I have to say that seems to me just to be completely wrong. I mean, I can't understand that. But anyway, it must at least be probative of the question. But putting that to one side, that's not our case. Our case is not they're probative of that issue. They're probative of what was going on in terms of systems and controls and how the bank's processes were being used to evade or aid in sanctions. Subparagraph C, don't evidence PDMR knowledge of falsity of alleged statements. Well, we've debated that. Subparagraph D, the production of redacted copies. I mean, the judge remarked that he didn't know why the bank thought it was entitled to do that, and we don't know why the bank thinks it's entitled to do that. I mean, it's accepted that these things are relevant, and they've just gone and redacted them in documents that they've produced.
Well, it's because of a SAR point, presumably.
It's because this application
It's
is
because this
outstanding.
application is being
They're
made. I
waiting
don't find
for
that difficult to understand.
Well, maybe they'll become unredacted. But anyway, it doesn't help us to get redacted documents because we can't see what the documents say.
Well, it's a point and issue between you.
Exactly. And then the internal documents that led to the SARs are not subject to restrictions. Yes, okay. It goes back to Lord Justice Snowden's point that the SAR will synthesise what went before and create the footprint of it. So those are our submissions on the judge's decision on relevance. That, I think, then takes us to ground 3, which is that the judge failed to exercise his discretion properly. And this is where 2 points arise, I think, and they are distinct. One is the comity argument that my learned friend addressed you on at the start of his submissions. And then the second is the weighting, which is an interesting point. Where is there a weighting in the balance, and if so, is there what is it? Where does it sit in the balancing exercise? So the comity argument is that even if the judge was right to find that there was no real risk of any kind of sanction whatsoever, he should have exercised his discretion so as to protect the interests of the US financial regulators and dispense with disclosure. That's what it amounts to. And that's in fact the only argument that is available for the CSI documents, because we know there is no risk of any sanction in respect of those. We say that novel argument is just wrong. The judge did deal with it. It was addressed to him, and he deals with it in his analysis of the law at paragraphs 38 to 41. It was on that occasion, my learned friends, leader Mr. Handyside, making these submissions. He goes through all of the authorities which concern what I'm going to come on to call the structured discretion that arises under the Bank Mel Act jurisprudence. He addresses those authorities. And he refers in paragraph 38 to the submission that he should pay a lot of attention and respect to the US regulators' strict requirements of confidentiality, which have an evident public purpose. He goes on to refer to Abacha and other authorities that were referred to in the course of that submission that was made by Mr. Handyside. And he does that in paragraph 39, referring as well to the Singaporean regulators, the way that the FCA confidentiality provisions are dealt with in the real estate case. He deals with our submissions at 40. And at paragraph 41, he then draws all the threads together to say, right, what do I make of all of this? We've got real prospect of prosecution, we're being told that a regulatory sanction could be sufficient, and we're being told comity could be sufficient. And what he says is if the defendant cannot show a real risk of criminal prosecution, it seems to me the law is against it. We say he is absolutely right about that. So why is he right about that? The answer starts with Bank Mellat at the latest, which is a case which has been applied numerous times. My lords have the decisions in the PIF's case, Glencore. There are sort of 7 or 8 decisions in the bundle, I think, and there are more that are not in the bundle. Those decisions are to the effect that where a private litigant contends that it will suffer adverse consequences under foreign law if it has to give disclosure in the courts of England and Wales, the court will apply the discretion that arises in respect of confidentiality in a structured way. And that structure, it's very familiar now. First part is to ask, is there a real risk of prosecution or potentially some other adverse consequence? And the second part is you do the balancing exercise. If so, the court considers whether the documents could be significant and their significance is weighed against the risk. And my lords have seen what Bank Mellat says about that and the other cases which are cited by Mr. Justice Green in the course of his judgment. The defendant's argument is that you can put all of that in the bin for today's purposes, and instead a private litigant can argue that even though nothing bad will happen to them, the foreign state's policy objectives are jolly good and should be promoted by this court and should trump English procedural rules. And we say that is just wrong in principle.
I mean, I just wonder whether the Bank Mellat of itself deals with a different situation. Actually, if one's thinking about these issues, they should be approached through the prism of the law summarised in paragraph 31 of Abacha. You've got confidentiality. Where there's confidentiality, normally there has to be disclosure, but the court can weigh things in the balance. And in weighing things in the balance, they can take into account the interests of third parties, presumably including the foreign regulator. Why couldn't one approach things in that way?
Well, there are a number of sort of different issues with that. The first is that it's not the law, and we do actually have Bank Mellat, and that's a decision of this court. Which
Bank Mellat is a decision on risk of prosecution. We do have the law in the decision of the House of Lords in Science Research Council and NASE. That's law. Why couldn't one view things through a NASE type prism?
So, I mean, if one were to, as it were, start from first principles without, as it were, the framework of the cases that are currently in place, I mean, there are a couple of reasons. My lord, the first is in terms of certainty. At the moment, we have a situation where there are a number of cases which all start with the principles applicable to common ground. So these are commercial cases in which it's important that there is a predictable framework for decision making. And the point about this framework is that this is the way that the English court gives effect to comity. So it doesn't just ignore the foreign state's desires or interests. It looks at them through a particular prism, which is, okay, they might care about it, but are they actually going to do anything? Because that would be really quite good evidence that they really cared about it. And if they were really going to do something, then of course that would weigh heavily. So comity very much comes into the Bank Mellat approach. And it's right to say it's not only been considered in the context of criminal prosecutions. I mean, as my lord says, that was Bank Mellat, but Palladian Partners is not a criminal case. And there's no reason in principle to think that it should be limited to that. But once you move away from having to address a narrow and clear factual question about whether the foreign entity will do anything to you, where does the certainty come from? You have a sort of untethered discretion to consider what the foreign state might feel like doing. To Lord Justice Snowden's point, well, how's English court going to regard the needs of the Americans versus the Russians versus anyone else? I mean, it is a license for these types of issues.
But I'm not sure how far this actually arises in the context of this case, really, but just thinking round it. Suppose there's a question of a litigant in an English case having to disclose a confidential document. Say, I mean, perhaps a document that includes a trade secret. The court, applying ordinary English law principles, would think about what to do about that. Normally, confidentiality doesn't stop disclosure, but it potentially can. The court has a discretion. The fact that the person who benefited from the confidentiality was foreign wouldn't make any difference, or needn't make any difference. The English court would still worry about the rights of the foreign third party. Why shouldn't the English court still worry about the rights of the foreign third party regulator?
Well, because it arises under a foreign system of law, and the English court principally applies English law.
Well, suppose the right of confidentiality of a private person arose under US law. We'd still worry about that, wouldn't we? I mean, why should the fact that suppose there's a contract providing for confidentiality, the fact that it's governed by the law of an American state wouldn't make any difference, would it?
I mean, well, it may or may not do, but the trouble with if all you've got is that there are sort of different pockets of cases with this. There's the Abacha pocket of case, which is about mutual legal assistance, and there are cases where there is a concern of something happening under foreign law. Then there are cases where there's just some confidence, and the difficulty with sort of using that to obliterate all of the others.
I'm not going quite that.
is those cases tend to go in the same direction, in the sense that confidentiality doesn't override disclosure obligations. It's only if the document, well, if I accepted this, it'd be quite an exceptional case where the court says, that person's confidentiality is, whatever system of law it arises under, is going to trump the need for the opposing party to have these documents. It would have to be, either have to be disproportionate, and this is the Tullett and Prebon point. We've cited the decision of Mr. Justice Coulson as he was setting out the principles. I mean, it's in the sense the same as Abacha. There is a balancing exercise. You consider whether they're going to make any difference, whether it's disproportionate to produce them. But if all there is some private law of confidence, then invariably, if they are material, they will be.
Certainly, if they're thought to be necessary to achieve a fair trial.
Certainly, but obviously the point in time at which that decision is made, it's not that easy to tell, and so the threshold must be set very much lower than that.
Yes.
So,
And just on the point that Lord Justice Newey was asking you, in Bank Milad, Lord Justice Gross does actually start with that passage from Abacha, paragraph 31, in paragraph 55 of Bank Milad. So he does take that as the very first principle, and he does treat it all as a sort of as a species of confidentiality.
yes, but I think whether Defendant is right to refer to it as an offshoot, but where we part company is that Abacha is also in a sense an offshoot. What sits above it is the general principle, possibly from NASA, that confidentiality, the court has a discretion and confidentiality may result in non-disclosure. You then have a pocket of cases, as I say, concerning with mutual legal assistance where it arises in a very particular way. And then you have a pocket of cases where there is there's a better case for non-provision of the documents. That's the point. And you're instead saying, well, there's this other thing going on here, which means we actually shouldn't have to provide them. And that's the case that's being made. If they're over here in this case, it's going to be, well, you provide the documents. They're just confidential to some other person, but you're going to have to provide the documents because they look relevant. So
I've sort of lost the thread, isn't it? I thought my lord was putting to you that it is possible that obligations of confidence owed to a foreign regulator might justify non-disclosure. I mean, they might. It depends, doesn't it? I mean, confidentiality is not of itself a justification, but it could, depending on the nature of the confidence and the probative value of the document or the potential probative value of the document, justify it. So why shouldn't we take into account as an obligation of confidence the obligation that's owed to a foreign regulator? I mean, it can be taken into account. You're not saying it can't be.
no, not at all. But it in and of itself would be very unlikely to lead to an order that dispenses with disclosure. That's our submission.
I mean, it's the key being the word of itself.
Exactly. Yes. It's relevant and it sits in the background, but it's not a weighty factor unless you're in the territory where it looks like that somebody will actually do something to you if you breach that obligation. Then it becomes a weightier factor because you're in the structured discretion of Bank Mellat in the later case.
What should I mean, if you have a private obligation of confidence to which the law would generally give very great weight as a matter of just policy, why does the fact that the person whose confidence would be infringed can't do anything about it in terms of criminal sanctions or otherwise? Why is that? Mean that you can't take it into account? I mean, let's just assume that the law provided a great degree of protection for information disclosed to a medic or to a priest or something like that, and they can't do anything about it if you breach the confidence. Sorry, the person who conveys the information can't do anything about it if the confidence is breached. But I'm struggling. Sorry, I'm struggling to understand why you seem to be adopting quite an absolutist position, or I just misunderstood what you're saying.
I certainly didn't intend to adopt an absolutist position. I think what I'm saying is that where you have an argument that there will be actual consequences in respect of breach of that obligation, then it's clear how the court will approach it from Bank Mellat and all of the later cases. Where you have something less than that, which might be simply somebody will be upset or somebody wants their confidentiality respected or whatever it is, then yes, it's capable of being a relevant consideration. I entirely accept, because there is a discretion. But in view of the structured discretion that applies in the former case, it's very unlikely to be one that results in dispensation of disclosure.
I mean, certainly in ordinary English litigation, the discretion exists, but as you say, habitually, normally, disclosure follows.
Yes, and yes, if it's an English law confidentiality obligation, then disclosure, the order of the court permitting disclosure would normally be a defence to an action for breach of confidence. So, in a sense, talking about it in domestic terms.
But actually, true, it might be a defence, but that doesn't quite answer the concern of the English court. The English court does think about the rights of the third party. Normally, disclosure follows anyway, but not invariably.
No, and of course, if it's a serious concern, then often the answer to that will be to disclose into a confidentiality ring.
Yes.
So the confidence is protected because the provision of a document doesn't just make it a public document. It's normally provided in lawyers only or some slightly more elaborate confidentiality ring. And that's what we seek in this case. So I think what the point I'm perhaps trying to make is that what you can't have is a situation where, it said, well, we're not going to face any sanctions in Iran, but the Iranian Sharia customer confidentiality law is a terribly good thing, and the English court should pay attention to that and should give effect of that. And we said that's just a wrong term. There is a very clear way that these cases are dealt with, and they should be dealt with in a clear way. And that sort of open textual analysis runs into all kinds of problems, quite apart from certainty, is workability. How is the court supposed to make a decision about that?
For what it's worth, we don't nowadays have up-to-date white books in court, but we do have out-of-date white books in court. And the 2022 white book dealt with confidential communications in the notes at 31.3.34. A litigant is not entitled to claim privilege for documents and information merely because they were supplied with confidence and so on. The court may protect the confidentiality of documents by ordering disclosure initially to legal representatives only, and so on. Party may be able to resist the disclosure of confidential information relating to a third party where the disclosure would involve a breach of the third party's Article 8 rights. It doesn't help very much. I think you're right. As in general, at least if documents are thought to be necessary for the fair resolution of an issue, disclosure will follow.
My lord, yes. Well, yes, I think if I can sort of refine my submission, it's that whatever the general position might be, in the circumstances of this case, whatever regard the court is able to have to the interests of US regulators, in the absence of credible evidence of a risk of prosecution, if we're assuming the judge is right about that there is no real risk of prosecution, the balance is going to be struck in favour of disclosure. It's not a sufficiently weighty factor in the absence of a real risk.
And in that context, I think you can again invoke all the factors you invoked earlier about going into a confidentiality ring and very historic events and so on.
Yes.
There's no danger of tipping anybody off.
Exactly. So this is precisely the point that Mr. Justice Henshaw makes in the PIF's case, which is when he says comity is freestanding, it doesn't only arise if there's a real risk. What he means by that is even if I decide there's no real risk, I can still say, well, the Swiss Court of Appeal have expressed concern about these documents making their way to the Kuwaiti state, and so I'm going to put it into I can still do some comity at stage 3 and make sure that they don't get hold of it. So that's right, Lord. And yeah, we say that you can't, with respect to Batcher, doesn't really take things anywhere, because all it tells you is that there is a balancing exercise. It doesn't tell you anything about how to do that balancing exercise in the context of this case. Bank Mellat and the PIF's case and Glencore and Renault case and all these other cases, they tell you how to do the balancing exercise in this kind of case where it is alleged that something bad is going to happen to us. Now, if it's no longer alleged that something bad is going to happen to us, all you're left with is the general discretion in a Batcher. And all the Batcher tells you about that is if the document is basically not very important, which is what Lord Justice Cross found, if they don't need these documents, then he might dispense with the inspection, he might permit the redaction, but beyond that it doesn't tell you anything. And I mean, in fact, a Batcher is in a sense quite a straightforward case, because as my lords discussed with my learned friend, the confidentiality obligation in that case is on it's on the government arising under treaty, and has then been recognised in a series of cases where it has been upheld. So it's in fact an English law confidentiality obligation that's being applied in a Batcher. It's quite different to applying the law of a foreign court. And we do say, just the final point on this is just picking up my Lord's point, that even if you accept that one has to have great respect and regard for these confidentiality obligations, that doesn't justify non-disclosure on the facts of this case. The first important point about that is that consent was given by the regulators for categories 5 and 6. So those are all internal documents that refer to the CSI or talk about the CSI. The regulators didn't read those documents. They were provided with a sample. There's loads of them. So for all they knew, they contained descriptions of the very thing that they are saying you definitely can't have, and it's terribly important that you shouldn't disclose these documents. And that's a really telling point. And the judge relied on that point. It's paragraph 73 of his judgment. And the second point is that, realistically, it is, we say, fanciful to think that provision of these documents in this case could actually have the concern that's expressed. It's going to be terrible for banking regulation. People will clam up. We say that it's really not realistic. For starters, the documents are going into a confidentiality ring. While there is a group of claimants which is quite large, these documents have been restricted to 2 effectively decision-making claimants. So they're not being distributed to lots of people. It's just lawyers and the 2 selected claimants. If the defendant is right, then of course they're all of completely tangential relevance and they'll never see the light of day. So they'll just disappear. If needed at trial, it can be managed. Sit in private if needed. The most sensitive documents, we're told, categories 1 to 3, they're very few in number. We say it's really just not realistic to think that the provision of these documents in disclosure would have any impact on the way that regulators do their job, or, as the DFS puts it in their letter, would devastate its ability to carry out its regulatory responsibilities. And just finally on this point, there was a bit of praying in aid, things that English cases have said about the importance of free flow of communication in banking regulation. Obviously don't dispute the fact that in general terms that's a good idea, but of course, my lords have the point that those are English cases which are applying English statutory law in FISMA about confidence. So there's no discussion. It's not sort of, is it a good idea or not to order disclosure? It's, here is the statutory framework. Does this fall within a relevant exception? That's what both of the cases in the bundle are dealing with different arguments about statutory construction, effectively. It's suggested that in this kind of case, the English court should apply, effectively, look at the US law and look at whether there are exceptions. We say that that is wrong in principle. So, my lords, that is the ground 3.1 issue.
Without wishing to get too
Yes.
picky, can you just say that last sentence again?
In fact, I'm not going to say that it's wrong in principle, because I think that would contradict the refinement of my argument.
I think you did revert to a bit of absolutist.
Yes. No,
you were saying it's wrong in principle for us to have regard to it.
I'm retreating from my.
Sorry.
Yeah, I was just reading notes which hadn't unfortunately changed to keep up with my changing submissions. My lord, finally, the rest of ground 3. This is to do with the weighing, how the court weighs the balance, and we say the judge was right about that. This all comes from the Morris case, where Mr. Justice Neuberger expressed the view that the court would lean in favour, possibly heavily in favour, of disclosure, and we say that's obviously significant given the eminence of the tribunal and the fact that the language has been cited in a number of later cases. Can I show
It seems a bit of a curious sort of picture that judges are asked to weigh things in the balance, but with a finger in one scale.
It may be said, sorry to also ask another question, but before you answer that one, but Lord Wilberforce had an interesting point to make in the Nassau case, which is that there's this what he called a well-worn metaphor of a balance, but that presupposes that you're dealing with commensurable things. And here you've got two arguably quite different things. You've got the importance of the documents for the litigation. On the other hand, you've got, say, a duty of confidence. That's what he was dealing with there. And he basically said, without quite throwing out the metaphor altogether, that what it really is a exercise of judicial judgment. And I think there's quite a lot of force in that, because all of these metaphors of balance are no more than a metaphor where you're dealing with different sorts of things. And it does strike me, at least, as Lord Justice Snowden suggested, as a bit odd to call it a balance and then say it's weighed one way to start with. A better way of looking at it might just be to say they're different kinds of things, and the court has to reach overall evaluative exercise using its judgment.
I suppose the difficulty that faces the first instance judge is how do you weigh the apples against the pears? That is a problem inherent in this test. I think my response to my Lord's question is that whatever language is used, this series of cases that use this encapsulated test about leaning in favour, what they're conveying is that the requirements of English procedural law will normally take precedence. It's giving the judge some help with how to weigh those factors which are qualitatively different. So it might even be described, perhaps introducing different problematic language, but as a sort of default position, which needs to be taken.
Well, could it be expressed in terms of a burden, where you don't then need any language of weights and so on, but you just say that the normal position is that parties must disclose documents. That's a rule of what has been said in one case is playing the game according to English rules, because that's how we do litigation. If a party wants to come along and persuade the court otherwise, it has a burden of doing so. Does one need anything more than that?
Possibly not. I suppose it's a question of what would be helpful. I suppose what one sees from the cases is that judges have, it's cited by Mr. Justice Henshaw in the Piffs case, this passage from Morris. It's cited by Mr. Justice Cockrell in Renault. It's cited by Mr. Justice Bryan in Glencore. They've obviously found it helpful. Yes. Yes. And so I'm reminded that there's the language from Morris, and there's also the language from Matthews and Malek, which ends up being wound into the authorities and is actually referred to in Bank Mellat in Lord Justice Gross's sort of setting out the principles, which refers to rarely be persuaded. So it's almost a sort of, it's like an empirical point. This is obviously not what his lordship meant, but one in five goes will rarely be persuaded, and in fact that's what the authorities looking at it empirically today demonstrate, that exercising their judgment, all these judges have come to the conclusion.
English law might be thought to value disclosure in the context of achieving a fair trial, and that value has a part to play in the decision.
Yes, exactly. No, that's exactly right.
I mean, isn't that why I was just a little sort of picked up the point before I got to it, but rather than sort of talking about balancing two things which are not, as Lord Wilberforce said, commensurate, is it not better just to remind oneself that you've got a judicial judgment to make with a view to fulfilling the objective of ensuring a fair trial? Or to what Mr. Justice Coulson, as he then was, said, actually, Mr. Justice Peter Coulson, QC, as he then was, said, is disclosure proportionate and necessary to ensure that the case is dealt with fairly? That's the overriding objective, and that's the judicial judgment you have to make, rather than getting into a sort of mental gymnastics of trying to erect a pair of scales and then put two things in which aren't necessarily commensurate. And I think that's what.
Yes. I mean, I suppose one issue with that sort of formulation in a case like this, I'm not saying necessarily this case, but if the judge is, sat a year, 2 years before trial, dealing with the disclosure issue, trying to decide if the case can be dealt with fairly without disclosure of documents that he hasn't seen, which are of contested relevance. If that is the focus of the inquiry,
Well, I think it said that they would be relevant but of contested weight, wouldn't they? Or sorry, I've used the problem of the scales again. Relevant but of contested significance or probative value, potential probative value, or something. Yeah.
I mean, your submission is anyway that whatever metaphor one uses, that there is a predisposition that the weighing scales are slanted one way, and you say that is borne out by the passage in Matthews and Mallet, which is picked up by Lord Justice Grace. Is that your?
yes, and numerous cases after Bank Mallet as well. So, I mean, there is a certainty point as well here. Again, it tells parties what the court is likely to do, rather than it being a sort of. It would simply be more unpredictable in my submission if it was just a question of.
So your starting point is that documents which are relevant in the sense of having probative value or potential probative value to an issue which arises for determination of the case should be disclosed.
Yeah.
And so you start from that assumption, and the burden lies on the other side to say, but because of some overriding duty of confidence, they shouldn't be, and that a fair trial can be had.
I mean, there may be a stages point here. We're going a long way from this case actually, but maybe at the first stage, where it's a question of listing, you don't likely conclude that relevant documents are not going to be necessary to achieve a fair trial. Then, once they've been listed, you perhaps think again, and if necessary, there's an inspection process. I don't know, but anyway, this is quite a long way from this case.
Yes, well, I think I will finish, as I've used up my time, by saying that. Well, I think the first point is that if Mr. Justice Green has got the weighting wrong, then that is a criticism that will be levelled at all of the judges who've looked at Bank Mallet. Whether one describes it as weighting or something else, we say his decision was right. The part where he exercises his discretion was correct, having concluded there was no real risk. And at any rate, even if he was wrong about that, it was an insubstantial risk on the evidence. Unless I can assist further.
No, I think we've taxed you enough. Thank you very much, Mr. Patel. Mr. Allen.
I'll pick up just a few short points in reply. Starting with real risk of prosecution and the judge's use of the formula of real risk or actual real risk. There's no complaint that he used the words real risk of prosecution in his judgment. The complaint is about whether or not when he came to apply them, he applied them with the correct meaning. And the fact that there was no argument below about what the test was doesn't mean that the judge didn't go awry when he came to apply it. Indeed, it may mean that he lost sight of what precisely the test was because no argument was addressed to the point. My own friend has an observation or a point that one shouldn't pick over judgments like they're a statute or subject them to fine textual analysis. And as a general proposition, we of course accept that. I'm not sure whether it's right or wrong that whether the judgment was produced from notes or read out. I was at the hearing. My learned friend wasn't. I'm not sure I could say either way whether it was, but I'm not sure the point goes very far because the words that the judge used were very clear, and they introduced a section of his judgment where he deals with the evidence, and we do only have the words of the judgment to go on. And in my respectful submission, we are not subjecting the judgment to fine textual analysis. We're just looking at what the judgment says, and that is the best that we have. So that's all I have to say about whether or not the judge applied the right threshold test. In relation to past prosecutions and their significance, in the course of submissions today, the point perhaps parties may have moved slightly closer together on both sides, but it seems to me, at least on this side, that it's coalesced around the point as to whether or not, as the judge said he should do in the relevant paragraph of his judgment, consider the explanations in the evidence as to why there were no previous examples of prosecutions. And when one gets to the relevant paragraph of the judge's judgment in relation to the US SAR documents, we say that one doesn't find any consideration of the explanation that we give, namely that there have been no examples of US or foreign court orders in which the disclosure of US SARs has been required, and therefore there have been no prosecutions because it has never been required before. My learned friend in his submissions referred to a lively debate between the experts on CSI, but that's by the by in relation to the specific issue about criminal or civil sanctions for disclosure of US SARs. That's an entirely different point. And the judge didn't engage in our submission with the explanation that was given in the evidence and which was relied upon by us below as to why there were not previous prosecutions. In terms of assessing the weight of the evidence, we of course accept, I think I accepted this morning, that there is a restraint that is exercised by this court in looking at findings of fact below and evaluative judgments by first instance judges. But that does not mean that one doesn't look at the reasons or the adequacy of the reasons and the sustainability of the conclusions against the correct legal test, and whether or not the analysis that is there of the evidence provides a sufficient basis to explain why the judge reached the conclusions he did in a logical fashion that reflects the evidence. And we submit that when one does look at that one operative paragraph, paragraph 101, applying the correct standard test of a real risk, i.e. more than purely hypothetical, not illusory, not fanciful, and so on, one cannot see on any reasonable evaluation of the evidence how the judge came to that conclusion. Certainly the judge does not explain it in the judgment. And in those circumstances, our submission is that it's plainly appropriate for this court to overturn that decision. In relation to relevance, my own friend referred briefly to the Eurochem decision, Mr. Justice Bright, and the idea of the test being whether you can discount the possibility that the document might be of any significance. If that's being formulated as a test or the legal test, I should make clear we do say that that goes too far, in a sense requiring a party to prove a negative by reference to documents where they're constrained as to the ability of what they can say about them to satisfy the judge that they can discount that they'll be of any significance. In our submission, the safer course is actually to go back to what is said in Bank Mellat itself, which is that the court has to form form a judgment as to the likely importance of the documents to a fair trial. That's the straightforward test, and it's a positive assessment that the court has to make rather than ruling out a negative. And that assessment has to be formed by a positive engagement and critical analysis of the nature of the documents, such evidence as there is, including, in this case, unusually, if not uniquely, from the legal team that has reviewed the documents and has provided its professional assessment on the basis of its professional judgment. The issues in the case, and also importantly, an assessment of what else is going to be available at trial, because the other documents and the other source of the documents is a critical point in evaluating whether or not this subset of the disclosure is likely to be important for a fair trial. Because if the same material is going to be available from other sources, or alternatively, this additional material on top of the rest is not likely to be important in the final reckoning to the determination of the case, then that is a significant factor. And we do say that is an important point, especially in relation to the US SAR documents, but equally across, but also in relation to the CSI documents, because the proposition has to be put forward that the US SAR documents, the 16 unique documents, are themselves, against the other material that will be available relating to the developments in the investigations the bank's work to coordinate its response to the investigations and so on, will of themselves either be material in establishing misconduct that won't be evident from other material that does not refer to the existence or content of the SARs, or will be critical in showing that a PDMR was aware of the misconduct. So it posits a situation in our submission that a PDMR who's involved in the Larch investigations uniquely becomes aware of the US SARs and nothing else. That's one possibility. Or alternatively, that the content of the US SARs is so additive to all the other information that they become aware of in the course of the investigations that it's the US SARs that make the difference and are likely to be important to the fair trial. We say that's just utterly fanciful suggestion in terms of likely importance, the outcome of a fair trial.
Why is that? I didn't follow it when you said it the first time. I'm not sure I follow it in reply. In big institutions, lots of really complicated things happen.
Yeah.
And the people who know best what they mean, what relevance they have, how to interpret them, how to get to the bottom of what's happened, are the people on the job. They're the people who produce the SARs, they're the compliance team, they're the people who can do investigations, everything else internally. They have the best pair of eyes on the scene.
Yeah.
So that they're pulling together of all the material and putting it in one place with their knowledge as their job provides, at least potentially, provides real added value that just somebody coming at it 10 years later and looking at the underlying documents won't have. But why do you, unless I've just misunderstood what you said, you made the same point again, that if you get the underlying documents, the SARs don't add anything.
So I am making a slightly different point, which and I should clarify because it is important that, as your lordship will appreciate, there were a huge investigation was done within the bank for the purposes of responding to the for dealing with the matters that led up to the 2019 settlements over a number of years. The US SARs and the US SAR documents, between them 16 unique documents, form part of the material that was provided to the regulators in the course of that investigation. But among a whole load of other material internal to the bank, which can be disclosed, subject to privilege claims, and there's also CSI material, which is the other limb of this application. But that material will deal with the subject matter of the regulators' inquiries.
But does that mean that, has somebody said anywhere, well, we've looked at the SARs and that we can say, without telling you what's in the SARs, that there isn't anything in the SARs that isn't in the following documents?
The evidence about the relevance of the SARs is what Mr. Lewis says in his statement. But my broader point is this, which is that
It doesn't say that, does it?
it doesn't say that, no. But the point is that there are various alleged representations that are being made about the adequacy of, in quite broad terms, the representations are alleged to be made in the published information about the adequacy of our control systems, whether or not we've been effectively engaged in Iranian business, over and above that which had been disclosed in the 2012 settlements and so on and so forth. The suggestion would have to be that a PDMR's knowledge of the content of the SARS was what made the difference, either between those representations being true or false, or between a PDMR knowing that those representations were true and false, when taken alongside of the whole other wealth of information that any PDMR who was involved in the investigations was likely to receive. That's the point. But so I take your point, but there may be specific pieces of detail about a particular transaction in the USR that may not be found elsewhere. I understand that, or that may not be synthesized elsewhere. So I take that point, but it's a broader point about whether it is realistically plausible that the US SARS are going to make the difference between either the published information being true or false, or a PDMR knowing it's true or false. That's the fundamental point. In the context where the suggestion being the US SARS may come to these people, the PDMR's attention in the course of the investigations, and it's very unlikely in our submission. Just one can kind of infer that if a PDMR is involved in one of these investigations, they're not going to be involved and only see the SARS. That seems pretty. If anything, one would expect the reverse to be true. That a PDMR may not see a SAR because they are subject to restrictive confidentiality rules, but they may be aware of other stuff that is being reported to the authorities. So that's the only real point I had on relevance. I hope that as best I can has explained the point I was trying to make. Then, in relation to the balancing exercise and the point about weighting, I think I accept the proposition that plainly disclosure is a default position, and the party seeking to displace that bears the burden of persuading the court that that's the appropriate order to make. I think where I part company with my own friend is the suggestion that the court should approach that with whatever one might describe it as a presupposition, a presumption, an assumption, something of that ilk, where there is some extra added burden to knock the court over one line or one way or another. In our submission, what is required is effectively a fair and balanced weighting of these incommensurable. I'm going into the scales again, but one shouldn't start enter the exercise thinking that unless something very, very unusual happens, this is going to be the outcome. One should come in with a neutral mindset in my submission, albeit recognising that the burden is on the party seeking to displace the default position to persuade the court that that is the appropriate order. But it shouldn't be a weighted exercise in our submission. And as regards the observations in Morris, I just have 4 points really. One is that Mr. Justice Newberger's comments were expressly overt, indeed introduced by the words "not necessary for my decision." The second is that the Morris case concerned the French blocking statute, which the English courts have repeatedly found to give rise to at most a purely hypothetical risk, perhaps not at all. And so there is a danger in our submission of extrapolating out from the specific circumstances of that case to a broader, generally applicable proposition. Third, it was a case where Mr. Justice Newberger had already concluded that there were a substantial number of important documents. And so one can see that may well colour the assessment that the judge came to. And we do say also that those open to weren't cited or approved by Lord Justice Gross in Bank Mellat. He does refer to the passage from Matthews and Mallock that my own friend referred you to. Our position in relation to that is that insofar as it's suggested that that passage supports a position that the balance exercise is weighted in favour of disclosure. We do not accept that that is how one should read that passage. And secondly, it's not picked up in our submission in the summary of principles, which follows in the very next paragraph of Lord Justice Gross's judgment. And indeed, one sees, in fact, in that paragraph, a reference to orders not being lightly made, being very mindful of the risk of prosecution, which, if anything, runs counter to the idea that there is some foot on the scales to lean in favour of disclosure. So that was all I had to say about the balancing exercise. I had one final point on subject to checking, but left behind, but no one has anything else that they want me to say on comity and where Bank Mellat fits in on all this. I think there was a moderation of my learned friend's position in the course of his submissions, although there was still some splitting between the absolutism and the relevant factors. In our submission, just to be clear, we say Bank Mellat is a decision of limited scope relating to cases where one is relying on a risk of criminal prosecution or potentially of other sanction, but it is not exhaustive of the terrain, even in the context of foreign obligations. And it is not sufficient in that situation to stop. If one gets to the conclusion that there is no risk of prosecution or other sanction to the litigant themselves, the court is still entitled and should take into account the rather different consideration of the third party interest, in this instance a foreign regulator, and indeed the public interest that underlies that. And we do one sees that. I don't think we have it in the bundle, but it's a House of Lords case involving the NSPCC. I think it's either C in the NSPCC or E in the NSPCC, in which the point is made that confidentiality alone is not generally a basis for withholding disclosure, but when combined with a public interest that the court wants to considers appropriate to give weight to, then it can elevate itself to that factor. And we submit that
that's domestic. I believe.
It is domestic, but it comes back to the points I was making this morning about the complications in this area of the law that are introduced by the fact that global banks operate across the world, but litigation operates on a territorial jurisdiction basis, as does regulation. And so one can very easily get disputes involving global financial institutions here, which will put in issue regulatory documents, which, if they were documents which were generated during the course of their UK regulatory relationships, would quite clearly come within the scope of the UK's regime and the public policy that underlies regulatory confidentiality here. But simply because the happenstance that the litigation also entails that financial institutions' regulatory relationships abroad, the suggestion seems to be that public interest falls away, or is somehow the court has to be blind to it, and that really is a problem if that is where the law ends up, because the same public interest is jeopardised, and this by albeit in the eyes of a foreign regulator as opposed to a UK one. And in our submission, the solution that my own friends suggest, which is, well, if it's a foreign law obligation, then really you're in the Bank Mellat decision-making framework, and we focus on the consequences of the party, doesn't adequately accommodate that broader public interest concern, which exists across across different different national regulators' regimes, and is often common between them, albeit not regulated on a transnational basis.
I'm just curious. I mean, I don't want to get too far into this.
No, I know.
But I sort of understand your submission. If there was evidence that the UK public interest would be materially affected by an order requiring somebody to breach obligations of confidence to a US regulator, because the FCA would come and say, look, the US regulator would basically stop cooperating with us. if our courts do this to them, then the game's off, and it's a real problem here in the UK. That would be a major UK public issue. But on the other hand, you could see it on the other side of it. It's some far-flung and distant regulator that we have no dealings with. Just so happens that an institution has a foot in both jurisdictions, and there will be no impact as far as the UK is ever concerned that foreign regulator may think that it's one of its duties of confidence has been infringed. I mean, there's just a wide cross-section of matters. Why does the court? I mean, the court can take them into account, but it doesn't have to give the same weight or same importance, attach the same importance to both types of situations, does it?
That may be right. I think that the I would just three points. First of all, we don't confine the submission to consequence of disclosure which is injurious to the UK public interest. Our point is a broader one, which is that there is a public in terms of the cooperation between regulators. Our point is a broader one, which is, for example, the US bank supervision regime has a public interest that underlies it, that is recognised within the US jurisdiction, which is broadly analogous to a similar public policy that's recognised here, and that we say is a legitimate factor to take into account. The second point is that plainly one can posit examples of sort of far-flung regulators who are perhaps of less significance or the court considers to be of less significance. This is not that case. We're dealing here with a UK bank and the regulators in the next a extremely important jurisdiction in terms of financial regulation across the world and international markets. So whatever the position might be with less famous or significant regulators, we say that there is a particular concern with UK-US regulation in any event. And the third point is it would just be a question on the facts in any event, that as to the evidence as to the significance of the public policies and so on that underlie the rules in the foreign jurisdiction. I haven't taken your lordship to them in the interest of time, but there are, as I said, the two letters in the bundle from the DFS and the Fed that make their position clear as to the public policies which they say in relation to the CSI documents underlie their concerns or their refusal indeed to give their consent to the disclosure of the remaining categories of CSI and why they say that is important to them as a matter of public policy. So we do have evidence on that, and they are public policy concerns which are remarkably similar to the concerns which have been expressed in the English cases about bank supervision regulation and the importance of its confidentiality in the UK. So those are my 3 points on that. I was just going to, on relation to the point on Dicey, we did find over lunch that it appears to have been, the passage from the 15th edition appears to have moved to chapter 7 from chapter 1. So it appears at the start of chapter 7. It is referred to by Mr. Justice Henshaw in the PIFs case, which is the tab 9 of the authorities bundle, page 156, paragraph 51. He refers to an extract from that judgment on the, sorry, that textbook on the topic of claimants.
So page 151.
156, sorry, did I say 151? I apologise. It's paragraph 51. And there's a quite pithy explanation of what is understood by comity in this context there, or at least what Mr. Justice Henshaw took it to mean in that case, which puts perhaps slightly more flesh on the bones. The only other point to take out of 51 is the point that comity is capable of playing a freestanding role. My learned friend rightly makes the point that in that case it involved imposing restrictions on the further use of the documents to stop a concern about outflanking mutual assistance and the documents finding their way back to the Kuwait government basically outflanking a process in the Swiss courts. But in our submission, the appropriate way in which to deal with comity depends on what the comity considerations are. So in this case, we say that the comity considerations could only be satisfied via withholding disclosure or inspection, and because that is the nature of the comity consideration relating to the need to maintain regulatory confidence. So, unless I can assist you further, that's all I had to say in reply.
Sorry, I don't want to prolong things. These are quite deep waters, and I asked a question much earlier in the day about the general rule about enforcement of foreign laws, and one of the exceptions, I think, is, or one of the principles of English law is that the English courts won't enforce foreign penal laws, but also won't enforce foreign public laws. And I suppose the question is this a roundabout way of you coming to this court and saying, I want you to enforce these US banking statutes? Isn't that in substance quite close to what the argument amounts to?
I'm not sure it is with respect, but it also brings you into the sort of deep waters of what it amounts to enforcement and the case on direct and indirect enforcement. And you have
that's why I call them deep waters.
But we say that's not what we're asking your lordship to do, either directly or indirectly, because we recognise that what your lordships have to do is, or what the English court has to do, is exercise the discretion that it has in relation to disclosure under its own, under the Lex Fori. But what we are saying is that in doing so, it can take into account that a foreign regulator, in this instance, on the basis of US law, has indicated that the documents are confidential as a matter of US law. Indeed, they are it happens that they are protected by US law, and that there are public interest concerns of the US, which can then factor into the English court's discretion. So we say this isn't a case of enforcing by the back door the US banking statutes. Plainly, we can't ask this court to do that, and we don't suggest you should. What we are saying, though, is that they are a weighty consideration when it comes to the question of whether or not the discretion should be exercised to order disclosure and inspection, or to permit Standard Chartered to withhold these categories of documents from disclosure.
But you are, to put it a slightly different way, although you are saying that, of course, the discretion that this court has to exercise is an English law discretion under the Lex Fori, you're actually saying that we should do the same thing that a US court would do if the position arose in the US.
That is the result for which I contend, yes. But my answer to the question is that's not on the basis that there's an enforcement of the foreign law. It's on the basis of a...
No, but you're just saying as a matter of comity, we should do here what a US court would do there.
In light of the evidence as to the public policy rationale and so on that underlies it, and the public interest that is a public interest that is recognised again in the UK legislation, the UK cases, yes.
I don't detect any more questions. So thank you both very much. You'll be surprised to know that we're not going to give judgment here and now. So you will be supplied with the judgment in draft for you to correct our English and our typing, but not obviously so as to re-argue the case. We'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to settle the points in the order that we make. Finally, though I know you'll be very well aware of this, I should remind you of the importance attached to the embargo. I think we've already had lists of those who you think should receive the judgment in draft. If we haven't, can we have them? And if you think of anybody else, you obviously need to come back to us to get that approved. But thank you very much for very helpful submissions.
Oh, was it not?
Thank you.
Just grabbing some photos. Different, isn't it?
Yeah, it's just that's a new legacy report.
Yeah, exactly. Last time I was in this case, probably sat behind. Oh yes. Yeah,